Hi, this is Juliana. In my Back to the Escrow Basics series, I talked about needing the buyer's title investing in part two. Today, under my Art of Escrow series, I would like to break down this topic. This is a bit longer of a presentation because there's so much more to cover. So feel free to hit that pause button if you need to take notes, to stretch, or to go to the refrigerator for some munchies, which of course have some for me while you're at it. But I would like to start out with my disclaimer, which is important because I can give you the different types of title investing, but only you with your legal and financial presentation are able to determine which one is going to be the best for you in different transactions. So here's my disclaimer. The information contained in this video is only intended to provide a guide in the various transactions to which the information is applicable in the state of California. No representation is made as to the legal validity of the information or the adequacy of it in any specific transaction. The information contained should only be used after consultation with your legal and financial counsel. The presenter, which is me, is an escrow professional and practicing in California only, and other states have different laws and regulations for which this presentation does not address. So why is title investing so important? Why is it one of the first things that the escrow officer will ask you when you go to open an escrow as a buyer? Well, in life and in living, there are three simple words which can lead to difficult and complicated issues. The first one being death, the second one is separation, and the third one is divorce. So let me explain the difference between title and vesting. The two words. Title means your status. Are you a single person that has never, ever been married? Well, you will take title as a single man or single woman. But if you are an unmarried person, a person who has been married before but is not married now, then you take title as an unmarried person. What if you are a married person and your spouse is not going to be part of the ownership? So you are going to be taking title as a married man or woman as your sole and separate property, and your spouse is going to have to sign a quitclaim deed, but that's a story for another presentation. You can be married and you're going to both hold ownership, so therefore you're going to be John Doe and Jane Smith, husband and wife. You could be a widow, which is a person who lost the husband and is not married now, or you could be a widower, which is a man who has lost his wife and is not married now. And finally, of course, you could be doing this in your revocable living trust. Now, I have to caution you that if you're going to do it under the trust, you need to set it up before you open an escrow, and you need to go to your attorney to set this up. So if you're going to take title under the trust, it will be John Doe and Jane Smith, trustees of the Doe Family Revocable Trust, dated such and such. Now, what is your vesting? Your vesting is your actual ownership. What vesting you choose will determine how your interests will be treated under law. So here are some questions for you to think about. What type of ownership interest should you have with others? How do you transfer these interests? Remind you that it could be a number of people. How do you transfer your interest? What type of ownership interest? What happens in the separation or a divorce if you happen to be a husband and wife? And what happens to your interest upon death? This is the biggest concern. What happens to your interest upon death? And how are debts between these owners going to be looked at? So the first one and the most common is joint tenancy. Any number of people can join in a joint tenancy. The ownership interests are the same. It's not divided, not split, and the ownership is all together at the same time. Look at it like a pot of lasagna that is brought to the table and put in front of all of you. Everybody gets to scoop it out and eat however much they want, but it's all there for all of you at that same time. When one joint tenant transfers his ownership in this joint tenancy out, he then breaks the joint tenancy, and everybody in that joint tenancy will then become tenants in common. If there's a separation or a divorce, you will need to negotiate with your spouse because, as I said, the interest is individual or communal. It's hard to define, so you're going to need to negotiate it when there is a divorce. When one joint tenancy dies, his interest automatically goes to the surviving joint tenancy without going to probate court. And this is the purpose and why it's so commonly used, because when one joint tenant dies, the surviving joint tenants will get the property automatically. The debt of one of the joint tenants can be sold to satisfy this debt. The joint tenancy will then be broken again, and the ownership is going to go under tenancy in common. What is tenancy in common? Again, it could be any number of people. The ownership, however, can be divided into undivided, equal, or non-equal percentage interests. Each owner has their own separate legal title to their particular interest, and each tenant in common can transfer this ownership separately to anybody else without affecting the others in this tenancy in common. If the person passes away, the interest must be left in a will, and it has to go through court. The debt of one of the tenants in common can be sold to satisfy, and the creditor who gets that debt, who gets that ownership to satisfy the debt, will then own the interest together with the other tenants in common. Here's a particular note for you. A husband and wife couple within the tenancy in common can own interest between themselves in joint tenants, in community property with rights of survivorship, or in community property. Now, what is community property? First of all, it's only between husband and wife. The ownership interests are the same. They're not divided or split. And the ownership is under one title altogether at the same time. Remember that pot of lasagna. The transfer of ownership from this property requires both of them to sign. And if they're going to go through separation or divorce, then they will have to negotiate how much interest they each have. When one person dies, his interest, now this is important, his interest is going to be left in a will, and it will have to go through probate court. The heir to that probate will own the property with the other living spouse as tenancy in common. The debts of one of the spouse will apply to both. So the whole property has to be sold to satisfy this debt. Now, what is the difference between community property and community property with rights of survivorship? Again, only husband and wife. The ownership interests are the same. They're not divided or split. And the ownership is all under one title all together at the same time. One person, though, can transfer the ownership with the proper declaration on the ownership transfer deed. And in a separation or a divorce, again, the interest must be negotiated. Now, this one is the important one. When one of the spouses dies, when one person dies, his interest will automatically go to the surviving spouse without going through court. This is the good part of joint tenancy added to the good part of community property. Together, it becomes community property with rights of survivorship. Now, the debts of one person will again apply to both, and the whole property has to be sold in order to satisfy this debt. So, community property with rights of survivorship is the newest method, It's been on the books for decades, but it's still the newest method of holding title between husband and wife. And like I said, it combines the good parts of joint tenancy together with community property. Let me give you some combination examples so that you can work with this and you can think about it in your transaction that is coming up. John Doe, a single man, and Jane Smith, an unmarried woman, as joint tenancy. So this is under joint tenancy. Another one under joint tenancy, John Doe and Jane Smith, husband and wife as joint tenants, or John Doe and Jane Smith, husband and wife as community property. Then we have, of course, John Doe and Jane Smith, husband and wife as community property with rights of survivorship. Now let's make it a little bit more complicated. We've got John Doe, an unmarried man, and Jane Smith, a married woman, as her sole and separate property. Each has an undivided 50% interest as tenants in common. Of course, this means that Jane Smith's husband is going to have to quitclaim his interest in her 50% share. But there you go. Here's a tenants in common. Or you can have John Doe, a widower, as to an undivided 75% interest, and Jane Smith, a single woman, as to an undivided 25% interest as tenants in common. Or, and this is the final one, and it's a very complicated one, so follow along with me. John Doe and Jane Smith, husband and wife as joint tenants, as to an undivided 40% interest. And then we've got Mary Smith, a single woman, as to an undivided 30% interest. And then we have Robert Smith and Ann Smith, husband and wife as community property with rights of survivorship as to an undivided 20% interest. And finally, we've got James Jones and Alice Jones, trustees of the Jones Family Trust dated January 1, 2019, as to an undivided 10% interest, all as tenants in common. Let me add this up. 40, 30, 20, 10. Yeah, 100%. There you go. When an escrow officer gets the escrow and sees that the sellers own something as complicated as all this, we all get a little bit of a headache, because just think of how many people need to sign and how many documents need to be prepared just to clear the title on the sellers. Well, that was a lot to cover. Thank you for sitting through this with me. If you feel you got good information, please subscribe to my channel. Today's t-shirt, and you know I always have a new t-shirt on. Today's t-shirt is my Batman t-shirt. It just shine that light and I will answer. See, here's my Batman t-shirt. There are many ways for you to contact me with your questions. You can leave it on the comment section or the community section. You can email me at hi@juliana2.tv, or you can go and visit me on my website, juliana2.com, and leave a comment over there. Thank you for watching, and I shall see you the next time.